Good morning, namaskar, sat sri akal, and adab. This is my 275th video, and this will be covering the point of ownership. Now, how does the honorable courts in India read into ownership, the dispute of ownership of land? A Supreme Court in the decision reported Government of Andhra Pradesh versus Thummala, Krishna Rao and others has very clearly in para 7 stated if there is a bona fide dispute regarding the title of government to any property, the government cannot take a unilateral decision in its own favor that the property belongs to it. And on the basis of such a decision, take recourse to the summary remedy provided by Section 6 for evicting the person who is in possession of the property under a bona fide claim or title. The apex court in the aforesaid decision observed in para 7, the summary remedy prescribed by section is not the kind of legal process which is situated to an adjudication of complicated question of title. Now, friends, we need to understand this ownership is when disputable, Public Premises Act cannot be imposed on our bungalows. So now what does the vassal states speak, which is under a suzerainty of another state? Its dependence is so restricted that has no importance under international laws. It is under guardianship of another independent state, a protectorate state, is which entrusted some of its important functions to another sovereign state and retains a sufficient measure of sovereignty and remains a state under international laws. Now, this is very important. Why? The Britishers, when they moved in 1757 or later, they were basically the protectorates. I have my Treaty of 1803 of Punjab with Sir David Auchterlonie, which clearly says that the Sikh Satluj states were protected from the invasion of the Punjab Maharaja Ranjit Singh. Now, we have to understand, I just narrated the ownership issue or the land issue. Now I am telling you about the protectorate state. Now, what happened in the cantonments? Now, I'll read from the book. The amalgamation of two companies as United Company of Merchants of England trading to East Indies in the year 1702 by Lord Golphin. From this period, the company's status was regulated by an Act of Parliament instead by charter from the Crown. The British ever since put their foot on Indian soil. They had declared some territories which could be safe for their living. Now, all the British were either traders or mostly men in uniform, that's army officers. The specified area in which they put their foot was called military cantonments. Now, during this British period, the British laid their foot on many such towns and villages and created them as military cantonments, but later abandoned them. Now, there is a list of more than 101 or 2 cantonments which they made or military stations. Though the Mazammat or the criminal jurisdiction and police powers remained with the Nawabs, the company till 1772 stood forth as Diwan, and it followed with an assumption Mazammat. Treaties were achieved between the Nawabs to restore peace in this area for the next 40 years. So, meaning by till 1812. Now, in 1784, an Act of Parliament had declared that no pursue schemes of conquest and extension of dominion of India are measures repugnant to the wishes, the honor of policies of the nation. So the 1784 Act clearly said that there's going to be no war, no conquest. So everything was going through a treaty that Lord Wesley determined to establish the ascendancies of the British power over all other states in India by a system of subsidiary treaties so framed as to deprive them of the means of prosecuting any measures of forming any confederacy hazardous to the security of the British Empire, and to enable us to preserve the tranquility of India by exercising a general control over the restless spirit of ambition and violence, which is characteristic of every Asiatic government. Now, Lord Wesley executed his plan with complete success, and when he left India, the Punjab, the Sindh province, and Nepal were the only territories which remained completely outside the paramount of British influence. That means till 1812, these parts were never a part of the British trade, which the area of direct occupation had also been greatly enlarged. The supervision over most of the important native states in India rests directly with the Governor General in Council. In some cases, however, historical associations have left relations with important states such as Travancore, Kolhapur, and Patiala under the local governments, which also deal with minor states whose territories are enclosed in or contiguous to their provinces. Besides the territories under the direct sovereignty of the crown, India includes nearly 700 native states, which cover an area of about 7,70,000 square miles and contains a population of approximately 64 lakh inhabitants. They differ from one another greatly in size and importance. The Governor General in Council was forbidden without the express authority for old grants, revenue free private estates of the Court of Directors or the Secret Committee to make war except for the protection of our own territories and those of our allies, or to make fresh treaties guaranteeing the integrity of a native state. It was the practical ignoring of these provisions by Lord Wesley under the stress of circumstances which caused so much friction between himself and the directors. Now, with this doing, somewhere Lord Wesley was doing something else what the 1784 Act actually told him to do by the Queen of England. So sovereignty was somewhere taken by the Britishers in some terrain, and some terrains the sovereignty was divisible. Now, what does sovereignty? Does anybody in this segment who's watching my YouTube can actually, before my answer, say that whether sovereignty is divisible or is sovereignty complete? Now, the position of the territorial chief or ruling auto old grant revenue free private estates is of less importance. The status of the territory and not that of its ruler is the essential point. Generally accepted is that sovereignty is divisible and that it attributes the division likewise. Now, what are the 5 points where sovereignty stands divisible? The right to make war or peace, the right to foreign negotiation, the right to legislate, the right to administer civil and criminal justice. The sovereign who enjoys all these rights is alone independent. In India, the accepted suzerainty of the British Crown involves a partition, the aggregate of such power between the suzerain and the prince. Accordingly, no ruler of a native state can be described as independent, that is, independent sovereignty. The native prince have therefore a suzerain power which acts for them in all external affairs and at the same time scrupulously respects their internal authority for old grant, revenue free private estates. So the Britishers were very clear when they moved in, what were their acts, how ownerships were to be defined, why PP Act should not be applicable on old revenue free private estates, because in the GLR, now friends, please understand, in the General Land Register, we are subscribed as old grant. Now, where is old grant defined? It is defined here. And now, when we are fighting for ownership, PP Act is not applicable. Now, what were the Britishers? They were the protectorates, not the vassal states. So when the everything is defined and pleaded likewise, we achieve what we want to achieve. Otherwise, these pleadings become immaterial. If you don't plead them correctly, you can never ask the courts for a remedial benefit towards your old grant, which has been since 12th August 1765, the cut date given by the Britishers. Once again, we are old grants, we were revenue free grants or Lucky Raj grants. If we were converted into new grants by the British or the Board of Revenue Officers, we cannot be called old grants. Thank you. Good day.